Well, a very good afternoon, everyone. I'm Tim Gilkerson, and on behalf of the in-house community, it's my great pleasure to welcome you to this timely webinar, Proactive Management of COVID-19 Related Risks and Disputes, presented by Kareena Tay and Philip Kwok of LC Lawyers, which is the Hong Kong law firm member of the global EY network. We're privileged to have two really experienced and knowledgeable lawyers to present to us today. But before I introduce our presenters, just a couple of comments on the forum and this platform. If you would like to ask questions during the presentation, and you'd like to put those questions forward to our speakers, please type them into the questions window on the webinar interface to the right of your screen. So you can see there's a questions tab there, and you can type the questions into that tab. It may not be practical or possible for Kareena and Philip to answer all of your questions during the presentation, but they will be made aware of them, and if not during the presentation, they will respond afterwards. Our presenters may also ask for a show of hands during the presentations, and to respond to that, you can just click on the raise hands icon, which is also on the control panel on the right of your screen. Finally, for those who require them, one Hong Kong CPD point has been applied for this webinar. And as part of this process, please do stay online at the end of the presentation to answer a few questions for us in the webinar feedback form. So that's enough from me. It's my pleasure now to introduce Kareena and Philip. Kareena Tay is a partner with LC Lawyers. She's the first female solicitor in Hong Kong to be granted higher rights of audience, a recently established designation that permits select, highly qualified litigators to represent clients in civil matters in all levels of the SAR's judicial system. Kareena has been recognized by Chambers Global and the Legal 500 for her responsiveness, excellent advocacy skills, and as a strong and experienced litigator. Joining Kareena this afternoon, we have Philip Kwok, who is a counsel of LC Lawyers. He focuses his practice on complex commercial dispute resolutions, regulatory investigations and compliance, and technology and e-commerce advisory matters. He regularly assists multinationals in resolving complex commercial disputes and advises on issues related to blockchain, cybersecurity, privacy, and data protection, digital signatures, virtual identity verification, anti-money laundering, and other legal issues related to the latest technology. So Kareena and Philip, thank you very much for putting this session together for us, and it's over to you.
Thank you, Tim. Good evening, everyone. Thank you for joining Philip and myself in this webcast, Proactive Management of COVID-19 Risk and Disputes. In the next hour, we are going to take you through a number of topics which can be found in the agenda in the following slide. As you can see, we will be covering legal issues and risks and sharing with you our views on how you can proactively manage these and plan for the future. First, a brief word about Philip and myself and how we came to put this program together. So between Philip and myself, we have 42 years of experience in disputes resolution and investigations work in this region. And if I told you the exact split, you'll be able to work out how old I am. Before joining LC Lawyers LLP, we were with international firms law firms helping MNCs and financial institutions manage risks and disputes in the APAC region, particularly in Greater China. And when COVID-19 hit us in mid-January, it brought back memories of SARS and what it did to our clients in the region, how it disrupted businesses and operations, and the things that we needed to do to help them. But of course, you will all know that the impact of COVID-19 has been many, many times worse. Its spread is global in reach, and the containment measures that have been brought about to try and curb the spread have led to significant global disruptions in business and operations. Let's have a look at the extent of the disruption to date and what's predicted in the days ahead. As you can see from this slide, there are tough times ahead, and the global spillovers will come via main channels such as reduced demands, downturn in the tourism industry, supply chain disruption, slowdown of economic activity, and very volatile financial markets. According to the EY Global Survey 2020, which surveyed 500 board members and CEOs across the world, 4 out of 5 respondents, which is 79%, had stated that their organizations were not very well prepared to deal with crisis events. But nonetheless, organizations facing these multiple challenges have put together crisis response teams to assess and to try and respond to the crisis that has hit us all. Due to the challenges created by the outbreak, the assessment, in our view, must necessarily include an assessment of legal risks and liabilities. And there must be a proactive plan to plan how to mitigate and to head them off. Otherwise, the effect would be even more devastating than it is now. Let's have a look at some of the examples of potential issues and risks that have emerged to date. On this slide, you will see some of the issues that we have identified. You'll see them classified into supply chain issues, customer and brand protection related issues, talent and workforce issues, insurance coverage and acceptance issues, financial treasury investment risk issues because of the downturn, and because of the technology age that we're in, we also have technology and cybersecurity related issues these days. And if you're in the listed or regulated sector, there will be also regulatory issues that need to be dealt with. Dealing with these issues need to be looked at in a global sense. We have to put together a plan because these issues, in our experience, don't come in isolation. And even if they do, there will be a knock-on effect, and it will snowball into out of control if not proactively managed. So what we've done is basically put together a plan with the slides ahead to discuss how we consider and recommend assessing the potential impact and proactive dealing with these sorts of issues. Our recommendation includes 5 key steps, and you can see on the left-hand side of the slide the headlines in terms of the steps. There'll be, in terms of setting up a proper response strategy, assessing the risk and preparing the response plan, implementing that, communicating with counterparties, exploring solutions and options, and planning for the future. But of course, it is not going to be a one-off step and plan through. You need to be sure to be continuing to monitor the issue, essentially because many of the issues that are starting to emerge are not issues that can be dealt with in one go. So ultimately, it has to be a system that will allow ongoing monitoring and response. It needs to include communication strategies, which will allow timely, consistent, and concise reporting of the issues, as well as in managing stakeholder interests and needs. The risk assessment and scenario planning will need to be part and parcel of this approach. Any issues that have already been identified and are evident will need to be dealt with. and to basically assess the ongoing impact on business and operations, and identifying key intervention actions. Next, there will need to be also a system of monitoring and analysis, bearing in mind the issues already identified and troubleshooting ahead. The situation analysis will need to include the different functional areas, because the issues that are being encountered are across the board and in all parts of the organization. So there will, for example, if a major supplier that supplies essential ingredients and components is struggling, you'll need to have a system in place that will monitor what is happening in the industry and also with the supplier in question. Keeping close contact will be necessary, looking for alternative suppliers and onboarding them, bearing in mind compliance risks and due diligence requirements will need to be done quickly sometimes and proactively. On top of that, there will be legal and regulatory requirements that need to be considered. And on top of that, communications dealing with the relevant stakeholders to ensure continuing support. Within this wheel, ongoing wheel, there will also need to be the implementation of the response plan, dealing with the issues that have been identified and preparing countermeasures in advance. And this will, of course, require an understanding of all the issues, the rights and obligations of the different parties, and to find alternatives and options, bearing in mind that many of these issues will have resulted from ongoing contractual relationships, whether it is your supplier, your customer, your financier, your investors. While there is an emergency, people will be reacting, but you need to also think about your long-term future and sustainability of your business. And very, very closely tied to that is your relationships with your stakeholders. So let's have a look at the first step, which is basically setting up a dedicated team and the protocols that will go with that. A dedicated team across functions is essential to this plan. In the context of the organization, it will be and should report to either the crisis team or preferably directly to the board, because the decisions that need to be made will impact the whole organization and they will need to have sign-off and be consistent with other parts, other crisis management related issues, for example, workforce management, business continuity issues. The objectives and responsibilities of this team will be to oversee the identification, assessment, and management of risk and potential breaches and disputes. Areas of likely coverage would be supply chain, if you're involved in the supply chain, customer and brand protection, which is key, talent and workforce management, and also related to that, insurance-related issues as an option. So essentially, the team composition, bearing in mind the issues and risks involved, will need to be cross-functional. It will also need to have people of appropriate seniority and authority and knowledge about the business. Otherwise, you're not going to be able to implement the plan and obtain the information and to be able to execute on the steps that are required. If there are too many members to the team, we would suggest having a core team within the larger team. And you'll see on the left-hand side of the slide, we have highlighted the core key members that we would suggest. The board representative, legal, because ultimately there are many, many legal issues, and there's also the question of trying to protect the sensitive information and analysis with legal professional privilege. Finance and operations, regulatory, compliance, and of course communications and HR. The other members can be part of the team, and they can come in and out as necessary depending on what the issues are. It will have to be cross-jurisdictional in nature if your issues are cross-jurisdictional, and bring in external professionals if and when necessary. Each member, we would suggest, should have clearly identified roles and responsibilities, and part of the matrix of the team will include communications. They'll have to oversee the communications, and with all the different people within the team having responsibilities for the issues that are unique to their area of expertise. For example, finance will deal with financial impact related issues. Regulatory and compliance will deal with those. Operations will cover the whole range of operations and bringing in sales and marketing, procurement, logistics, etc. as necessary. Now, with the dedicated team, there needs to be communications protocols. And let's have a look at some of those key things that need to be dealt with within the protocols. The communication protocols are to enable the team members to communicate with each other, with the people they are reporting to, for example, the board or the crisis team, and the persons reporting into the dedicated team. The communication protocols we would recommend should limit the communications with the board. There should be only one point of contact with the board to avoid confusion. There should be a limited sharing of the issues and risk plans, etc., with persons outside the team. The objectives are brand protection, maintenance of relationships, business continuity, enlisting support, and preparing for battle. The team protocols and communication protocols should focus on collecting information to be able to help identify, assess, and address the issues and risks involved. Inform on an as-needed basis, and communicating with the stakeholders. We would recommend an approach of timely, consistent, and concise communications. Timely because it's important to maintain confidence and reassure, avoid speculation, and allow proactive response. Consistent on coverage, openness, tone, and concise enough with information and not too much. In gathering information, there needs to be communication with internally from within the organization, but also externally. In trying to gather information, we would look for news coverage in the industry, what's happening globally, for governance guidance, industry updates, competitors, customers, workforce. And there will be a need to monitor the developments as the days go by. Apart from that, the communication strategies should bear in mind the objectives I just discussed, and there will be a need to protect what's confidential and sensitive, as well as to ensure that legal privilege is secured, because after all, you are going through an analysis of your risks and your exposures, and you don't really want to have to share this with your counterparty if you have to sue them or if they turn around and sue you. So developing and implementing internal communication protocols and strategies is key. For internal, I think you'll need to distinguish between what the team is doing to gather information for the purposes of your risk assessment. On the other hand, there will be a different approach when you're dealing with workforce welfare issues, such as health and safety, business continuity issues. Externally, you'll need to differentiate between the different stakeholders and develop specific stakeholder communication plans, which you would run past the board for approval before executing on those. Part and parcel, of course, with these communications protocols will be a need to protect privileged information. And let's have a look at that. As you know, legal professional privilege allows a client to protect confidential information between a lawyer and a client when it's for the purpose of obtaining legal advice. So the objective of this protocols is to make sure that these sensitive communications with your lawyer when you're getting advice, for example, when you're looking at things like analysis of risk and potential breaches, alternatives and options, mitigation and remediation plans, pre-action negotiations, strategies, etc. You don't want to have to be forced in a legal proceedings to have to disclose them unnecessarily. It's a different thing if you want to disclose them if they're beneficial to you. So some of the key points to remember, though, with legal privilege is this. It's not recognized in all countries. They are mainly recognized in common law jurisdictions, but each common law jurisdiction, for example, this between Hong Kong and the UK, will have different scope of protection and different requirements. But the key with most common law countries is that it's divided into two. One for legal advice privilege, that covers legal advice, but it's really only restricted to communications between the client and the lawyer. If you involve a third party, you risk losing privilege. On the other hand, you have litigation privilege, or what we call adversarial proceedings privilege, where you can involve a third party, like another professional advisor, a witness, or an expert. But in those, although it's broader in scope, it's also restricted to when litigation is already in place or reasonably contemplated. So these are some key issues that you need to bear in mind when setting up your privilege protocol. There are also jurisdictions where privilege is priced more than others. So say, for example, like Hong Kong, privilege is a constitutional right. It's not just a common law right. And the regulators in Hong Kong don't generally exert pressure to compel disclosure in return for leniency considerations. So this is something that you need to bear in mind when you want to seek your risk dispute management activities and to coordinate your activities. Some jurisdictions will have other confidentiality or protections, for example, some civil law countries, but the protection in those for confidentiality is not as broad. So coming back to why it is important to have privilege and what are the key ingredients, you of course need to involve a lawyer. And what you need to bear in mind is that not all jurisdictions recognize internal lawyers or in-house lawyers as lawyers. So again, you need to be careful in terms of which jurisdiction you're in. Involving external lawyers will of course increase the level of protection. The other thing to remember is that not all jurisdictions will recognize all employees of a client, that is a company, and or a corporate group as being part of the client team. So if this is the case, you'll need to set up specific legal client team protocols. So say, for example, when setting up your dedicated team for the purposes of risk and disputes analysis, you treat that team as your core team, and then you'll have this particular ingredient ticked off. So it's good to have a confined and a settled team for these purposes. The next point to bear in mind is you need to keep your communications confidential, and sharing it too broadly internally across jurisdictions with third parties and authorities is going to put at risk privilege in the confidential materials. So protocols would just need to bear in mind these issues that I've raised. Be conscious about where you would seek your risk and disputes management activities from restrict circulation by setting up your client group, restricting the communications between lawyer and the core team, providing only information that's necessary when collecting information from internal employees and from external parties. Don't send the communication into jurisdictions without legal privilege. And make sure that you use labels, but don't use, for example, privileged and confidential for the purposes of legal advice for proceedings that are contemplated, but don't use the labels indiscriminately. And specifically for email communications, keep your email chains short and do not forward BCC or CC to people outside the core team. So moving now to looking at how we go about assessing risks and potential breaches. Now we have our strategies in place. Coming up with a plan to address and mitigate these risks is key. So on this particular slide, you will see that on the left, we've had some examples of issues that have arisen from COVID-19, and on the right are different types of risks: operational, reputational, financial, performance, and legal risks. So looking at the wheels, you'll see there's a sample of the different things. For example, health and safety issues that arise because an employee has turned up sick, spreading the illness, it impacting not only employees, but also customers, for example. Loan defaults due to downturn of business, liquidity risks, data breaches because of flexible working arrangements, suspension of production due to workplace closures, closure of business and staff layoffs due to cancelled travel arrangements and organized events, delay and inability to meet orders and demands, or drop in demand because of social distancing, etc. To give this a little bit more color, we put together a scenario using supply chain. If you can see from the screen, we have a little story to tell. So imagine you're the general counsel of the Hong Kong listed wholesaler, which is dark green, the dark green box. Now, the wholesaler takes orders from retailers in Hong Kong and overseas, and it subcontracts the manufacturing to a mainland manufacturer. So that's the orange box. It has a major customer in the UK, which is a UK retailer, which is in, I think it's dark blue or purple, and that customer accounts to 40% of its total orders. In December, before COVID-19 hit us, it placed 2 substantial orders with the manufacturer for its UK retailer client. These orders had to be delivered before Valentine's Day. Separately, it entered into a financing agreement with a new financier on the left, which is a light blue in color, and it borrowed $50 million for the building of a manufacturing plant secured by a debenture. Now, looking at the mainland manufacturer, it usually orders raw materials from the Malaysian raw material supplier in the red box on the far left, who arranges the goods to be shipped to the manufacturer and processed. The manufacturer also engages a Chinese logistics freight forwarder company, which is the white box, to basically ship its goods. So for this specific order to the UK, it had made arrangements for the logistics supplier to supply these goods on the completion of the manufacturing. But due to COVID-19 outbreak and the containment measures, the mainland manufacturer was unable to resume its production and essentially did not deliver the first or second orders. They didn't make Valentine's Day, which resulted in the UK company then cancelling the contracts. The Chinese manufacturer alleges or contends that it's excused from performance because it's got force majeure certificates from the Chinese Council for the Promotion of International Trade. And then it also seeks compensation or payment from the Hong Kong wholesale company for the second order because it contends that the logistics company was responsible for the failure to supply because of the port closures and travel restrictions. UK company, as I mentioned, has cancelled the orders because they weren't delivered on time. It also says that it's not only these orders, but future orders, because there has been a history of poor performance, including substandard goods. All sorts of things are happening on the Hong Kong side. A staff member of the wholesaler was ill and infected other staff members and also customers. There was also a data breach issue because of lax cybersecurity protocols when they switched to FWA, so flexible working arrangements. And due to social distancing policies, downturns, there have been cancellation of orders from other retailers. Essentially, it's in poor financial shape with cash flow issues and liquidity issues. It can't pay its trade creditors in time and is struggling to meet its next rental payments to its landlord as well as its financiers. It's behind schedule in the building of its new plant, and while it can remember that it had some insurance policy for business interruption, it can't recall whether it paid its premium on time. So looking at this scenario, you can imagine the types of risks that have emerged from a performance perspective, from the different entities involved. From the manufacturer's point of view, it'll have to contend with whether or not the manufacturer is entitled to claim that it doesn't have to account for the failure to supply, whether or not it has to pay the manufacturer because it claims that the logistics freight forwarder was at fault and and it wasn't the manufacturer's fault. Quite apart from that, there are also the health and safety risks to be considered, and whether or not there will be liability for the mass infection due to its failure to put in place protocols to look after and contain and ensure staff welfare was looked after. And from a finance point of view, a liquidity point of view, there are issues as to whether or not it can basically carry on, or whether it needs to look at seeking some assistance in terms of restructuring, etc. Now, if you were, of course, looking slightly differently, because I do understand and know some of you have come from different industries, if you were the financier, you would also be considering whether or not all these circumstances have changed and whether there's a material adverse change allowing you to cancel the financing arrangement because the 50 million hasn't been drawn down yet. And if you were the insurer, you'd be thinking to yourself, oh, is there coverage for business interruption by the wholesaler? So let's move on to the next slide and look at the assessment of risks, having identified and gone through a scenario like that. Next slide, please. So essentially, looking at performance risk and the mitigation strategy, it's important to understand and evaluate what these risks are. And in most cases, understanding the risks and obligations are necessary, but you need to also specifically focus on governing law, because the law in different countries will be different, and have what may be a defense in one country may not be a defense in another. For those who are facing difficulties and inability to perform, you'll be looking at whether or not there are contractual provisions that allow you to delay performance, suspend performance, or to basically have an excuse for failure to perform. You'll need to consider what steps need to be taken and/or to mitigate losses. There are three examples from a Hong Kong law perspective of some provisions and legal doctrines that allow non-performance. And these are, as you will all know, force majeure, material adverse circumstances or changes, and/or frustration. The best way to deal with these issues in our experience is to actually make sure you have sort of like a checklist of the different options that you have, and to be able to work through them. So what we have on the slide is like a mini checklist, which you can actually take and expand on. So for example, looking at force majeure, it's only available if it's in a contract. So you firstly have to look for whether or not there is a provision in the contract. And secondly, is an epidemic a force majeure event? And what are the consequences of the force majeure event? Is it suspension or termination of the contract? And does it apply to these circumstances? Because force majeure requires performance to be impossible and unforeseeable and avoidable and beyond the party's control. So you need to go through these things based on the facts that are happening to you and your business. And then are there qualifying steps? So these are some of the things that you'll need to do in looking at and analyzing what the risks are and what you can or can't do. In the interest of time, I will move on to the next slide, which deals with other risks. So these are risks that are not really contractual risks, but risks that really evolve from some of the circumstances that you are facing. For example, if in trying to diversify your supply chain and make sure that you are not stuck with no production, and you'll be looking at new markets, new counterparties, etc. Have you essentially gone through the process of making sure that you have gone through the compliance checks before you engage suppliers, etc.? Similarly, there will be issues that arise because people are struggling. So say, for example, your sales and marketing staff have missed targets and bonuses and bonus requirements. Is there now a heightened risk that their bribes will be paid because they want to try and get the sales? Another example for logistics, trying to clear logistic log jams and be ahead of the curve to get your product out. Is there a heightened risk that bribes will be paid to clear customs or to get the last space on the cargo ship going out? All these things are things that you need to bear in mind, even though there are other issues that you may think are more pressing, because in the long term, they will be things that will be impactful for your business. Now, I've dealt with those very quickly because we are a little short of time, and I'm going to pass you over to Philip, who's going to deal with data privacy related issues that are also very key. Philip, over to you.
Thank you very much, Kareena. Coming to data protection, which is also very key because of the COVID-19 situation, I want to actually have a show of hands on a question and see how you're dealing with data protection issues. So if you are yes, can you please raise your hand? How many of you have been collecting employees' personal and health data concerning their recent health conditions, like where they have been, whether they have been staying with confirmed cases, whether they have been living in buildings with confirmed COVID-19 cases? Have any of you been receiving, collecting information like that? Thank you very much. So it seems a number of you have been collecting some, extra personal information of employees during this COVID-19 situation. In fact, when we talk about data protection in the COVID-19 context, we have to take note of at least 4 types of data that we need to protect and we need to consider during this COVID-19 situation. So the first type, obviously, is personal data of employees, like employees' names, IDs, address, their relatives, or even their location data. This is the first type of personal data that many companies are actually collecting in order for the purposes of protecting the health and well-being of the employees. The second type of data would require very careful handling, and that is health data and health history of employees, especially when you're asking your employees to disclose information about his or her health during this period, be it asking about whether the employee has a cough, has a fever, has upper respiratory symptoms, things like that. The third type of personal data of employees, or in addition to personal data, which require careful consideration, would be the company's sensitive and confidential information. It is particularly important because many of you are working from home and you will likely be accessing the company's highly confidential, proprietary data, trade secrets, sensitive information, and that may also sometimes include potentially trade secrets. The fourth type of data would include customers' personal and confidential data. Banks, financial institutions, logistics companies, online e-commerce platforms all collect a lot of personal and confidential information about their customers. And this is especially so when many of the procedures which are traditionally conducted physically are now conducted online, and there is a lot more face-to-face transactions where customers' personal and confidential data are processed in an online setting. So how would we protect all such data? How will we mitigate the risks of data breach or security breach when a lot of the traditional processes are now online because of the COVID-19 situation? Our recommendation is you should get a dedicated confidentiality and security protocol. Your protocol should cover at least 5 aspects. The first aspect is compliance with data protection principles. It is very important that your protocol must comply with all personal data protection principles under the Personal Data Privacy Ordinance. Some of these principles include whether or not the data you collected are necessary, adequate, but are not excessive. In a COVID-19 situation, the level of details of the personal data you're collecting from employees should fulfill all the 3 criteria, that it is necessary, adequate, but not excessive. Secondly, you would also wish to ensure that the data are kept not longer than necessary and are accurate. Thirdly, you would like to also ask whether or not you have informed the data subject of the purpose of the use of the data, and the classes of persons to whom the data may be transferred, and whether or not you have obtained an express and voluntary consent for using, disclosing, or transferring the personal data you have collected for a new purpose. It is a situation which has to be very, very carefully handled in accordance with the Personal Data Privacy Ordinance, or there are certain exemptions. For example, under Section 59 of the PDPO on health, it has a strict ambit, and any disclosure should be very carefully considered. The fourth issue, obviously, you will also need to have a data collection statement and policy ready and available and readily accessible. Also, have you got a proper procedure for handling data access and data correction requests? There are certain exemptions under the PDPO for, in particular, data access requests, but again, these have to be very carefully considered. In addition to compliance with data protection principles, another issue which your protocol should deal with is confidentiality measures for your work from home employees. This is especially important for protection of your company's sensitive and confidential information, which is now accessible from home, and a home may not be a particularly confidential environment if you're living particularly with your family members. So some precautionary measures would include whether or not there should be a mandatory privacy screen shield, whether or not you should use headsets for confidential calls, whether or not you want your employees, for example, to take calls in a separate room, or whether or not you have got protocols for printing companies' confidential information. Third area would be really security or information technology security measures. This is important for protection of all kinds of data, including personal data, health data, company sensitive data, customers data. And these measures should include consideration of whether or not there are sufficient technical measures to guard against unauthorized or accidental access, processing, erasure or loss or use of data, sufficient data backup measures, and measures to guard against internet fraud like identity verification protocols, and also any emergency plan if in case there is a data breach. The fourth area is compliance with sector-specific regulations. This area is rather important when you're handling customers' businesses during COVID-19. It's of course always be good to be innovative in the delivery of services during COVID-19. There are actually some areas where there may be specific regulations regulating non-face-to-face approaches to clients' businesses, as well as hosting of clients' data, particularly in the financial services sector. So it would be important that you will also have asked yourself whether you have complied with specific regulations concerning non-face-to-face client approaches to client businesses, and also compliance with the Electronic Transactions Ordinance and other provisions for electronic and digital signatures, matters like these. Finally, and indeed this is an area of an increasing concern because many of us are in a cross-border data transfer situation, and the recent closure of borders due to COVID-19 may have made cross-border data transfer something necessary and prevalent. Compliance with cross-border data transfer measures regulations are also quite important. For example, have you considered any applicable foreign laws and regulations which may concern cross-border data transfer, such as the European Union General Data Protection Regulations and the China Cybersecurity Law, which restricts certain types of cross-border data transfer, including personal data and data of critical information infrastructure. And further area of concern may be, state secrecy issues, where taking procedures online sometimes may increase the risks of inadvertent transmission of state secret information. And also whether or not your company is considered a critical information infrastructure under the China cybersecurity law. So there may be regulations that would apply in terms of cross-border data transfer. So these are essentially some of the obvious data protection risks. And the next step that you would do is to implement a response plan and report. Your response plan should include some key intervention actions, mitigation and contingency plans for dealing with the issues and the risks identified. The contingency plan or the response plan should prioritize in accordance with the importance and urgency of the issues. The very first step should be to, first of all, monitor performance of contracts and have an escalation system so that you would know the status of the performance of the contracts and their rights and obligations. You'll also prepare countermeasures in advance, bearing in mind the key issues that need to be addressed. And that include obtaining evidence of force majeure events or frustration, exploring alternative ways to perform, confirming performance of impossible and beyond control issues, and take steps to fulfill notification obligations in a timely manner. You'll also make sure that you would take appropriate steps to reduce losses, such as to explore options and alternatives as to the ways of performance of the contract. For example, looking for an alternative buyer, supplier or logistics, mitigation, and also seeking relief from government assistance programs or insurance coverage. It is also very important to document all the steps taken, the loss suffered and mitigated, and preserve and collect all relevant evidence. And finally, it is important to report and communicate, which include reporting to the board and obtain sign-off on proposed steps, and also report and communicate to relevant stakeholders. In a COVID-19 situation, communication is really the key. And the response plan, as we discussed, should include communicating with counterparties, as well as a strategy to explore options and solutions. The first key point is that your communication should be timely. Better that you approach the others rather than they approach you, particularly if you are the potential defaulting party. The factors to consider when you prepare to communicate would include considering the interests, positions, needs, and values of each party, strength and weaknesses of each party, the history and importance of the relationship to ongoing and future businesses and operations, knock-on effect on other relationships and obligations, alternatives in the market, costs associated with the change, compromise that can be made, and best alternative to a negotiated agreement. The tip is really to communicate and negotiate and be upfront about your ability or inability to perform the contract. You should explore options, be alert, and note the strengths and weaknesses discussed, and preferably you should not make any threats. And definitely don't close the door. Finally, the final key step is planning for the future. You should make use of all you have learned about your company's ability to deal with a crisis like COVID-19, including the strengths and weaknesses of its operations, its compliance framework, and its internal controls. These are the key steps for your action. You should review and renew your business continuity plan. And some of the factors that you should consider include your workforce-related issues like health, safety, etc., your IT security issues, your supply chain issues, your crisis management response, things like that. You should, secondly, diversify your supply chain. It would be recommended that you would consider whether you want to depend on only one supplier or have a further supplier options in your supply chain issues. And in doing so, in considering additional suppliers, you'll also need to make sure that you have conducted proper due diligence and compliance checks to satisfy legal, regulatory, and compliance requirements. Thirdly, you should review and enhance internal controls and compliance requirements and address any internal control or compliance shortfalls. Fourthly, you review and revise upstream and downstream contracts to include appropriate governing law, dispute resolution clauses, force majeure clauses, exclusion clauses, and to make sure that epidemics are actually included as a force majeure event. And finally, you should review insurance policies to ensure that you have got sufficient coverage to an epidemic event or epidemic disruption. With the advancement of technology, these processes need not be too cumbersome or costly, particularly when one have potentially recourse to artificial intelligence or legal managed services to lessen the load. Thank you very much, Kareena. Over to you.
Thank you, Philip. I'm wondering whether there are questions. I actually have one that I'd like to address. I had a question on which would be the best option, force majeure, frustration, or material change, adverse change. If after the dust has settled and you find that you can't carry on because of the impact of the COVID-19, I think we need to step back and really consider whether or not whether firstly force majeure, frustration, or material adverse change effect did actually take place. Ultimately, it's fact specific, and you need to look at whether or not you qualify. And first recourse is to have a look at your contract to see whether firstly you are entitled to exercise these rights. You can't just terminate your contract just because you have suffered catastrophic consequence because you can't continue your business. Termination without justification will make or open you to suit for wrongful termination. So you need to exercise care that way. It's not a question of which option is the best. It's really which can you really rely on. And you'll need to carefully consider your contract and also the circumstances that have led to the catastrophic consequence of your not being able to carry on business. I think, is there any other question that I can try and take while I'm still online? Otherwise, as we've said before, if you have questions, by all means, let us know, and we will endeavor to respond to them even after the call. I think we're about time, and I guess it just leaves me, I guess if you could turn on the webcam again so that we can basically say goodbye to our audience and to thank them for their time in listening and participating in our webcast with us.
There we go. So we can see you now, Kareena.
Thank you.
And there's Philip.
Thank you.
Thanks very much, Tim.
Thank you very
we
much,
thought
everyone.
It's good for us to say goodbye in person to our audience. Thank you very much for your time and participating.
We have one more question if you have time to perhaps answer it. And I think my colleague Raoul will share that with you now.
Sure.
Perhaps I'll read it out. If epidemic is not included in the force majeure clause, can we rely on a catch-all in the force majeure clause, i.e. not within the reasonable control of parties?
I think it really depends on a number of things, including where you are. Unfortunately, in this jurisdiction, particularly in Greater China, where we have had SARS many years ago, and it's going to be, I think, a balance as to whether or not you can say that an epidemic is not something that is within reasonable contemplation. Reasonable control is only but one of the elements that you need to actually satisfy. So I hope that that's clear enough. If not, by all means, shoot me an email and I'll try and help.
Excellent. Thank you, Kareena, and thank you, Philip. And if there are further questions, and I'm sure there are, we'll forward those on to you following this webinar. And I know Kareena and Philip will respond to you on those. So thank you very much. I want to thank Philip, Kareena, and Philip. There was an awful lot in that presentation. It was very comprehensive. So thanks to you and to LC Lawyers, EY, for putting this presentation together for the in-house community. If you would like a copy of the slides that Kareena and Philip presented today, you can do so. And I think my colleague Raoul is typing an email address into the chat box now, which you can request the slides via. But if you're not quick enough to copy and paste that out, we will actually send this to you tomorrow. We'll send you that email address and you can be in contact with EY and request these slides. Please do stay online after this session for the short questionnaire and to give us your feedback. That would be much appreciated. And we hope to see you soon, if not in a webinar, physically at one of our in-house community gatherings. But thank you, Kareena, thank you, Philip, and thank you everyone for joining us this afternoon.
Thank you.